Hello, everybody.
Mr. Patterson, are you ready to go with Mr. Whiteside?
Judge, anytime the court is ready to call the cases.
Okay, is that the only case you have left, sir?
That is all I have left. I don't mind if you take up Mr. Schwartz first, if it's quicker than this one.
Well, it may. This is stated, I'll call the Schwartz case, and is that Mikael Shane Schwartz?
Yes, sir.
Case number is 25 CR 431. If counsel would state their appearances, please.
Jared Regier on behalf of the state.
And you are Mikael Schwartz, is that correct?
Yes, sir.
Mr. Schwartz, are you represented by counsel?
No, like I told you last time, I didn't have the funds yet. I still have to give him $500 more. I'm going to get that done today, and then he'll be ready. But
All right, my notes reflected on September 19th, you were to put in an application for court-appointed counsel before the following Tuesday. Have you done that?
Well, I was under the impression that that I made too much money, so I was trying to procure. I really wanted to pay for a lawyer, to be honest.
All right, you were also told to appear in person.
I
or
talked to the
from
lady.
the attorney's office, and are you at the courthouse now?
No, sir. I called and talked to the lady at the district court's office about it, and she told me that I could do it on Zoom.
Well, yeah, and I imagine she wasn't aware that you'd been told that you had to be there. If you go and ask other people that weren't in the courtroom, it's very likely they're not going to tell you the same thing that the judge told you.
Sure, I
Now,
don't
there
remember.
was two things that you were supposed to have done, and you've done neither of them. You were supposed to apply for an attorney so that this case could be moving forward. And you didn't do that, and you haven't showed up where you're supposed to be.
I'm trying to apply for attorney. I got to pay the money.
Sir, you haven't done that. You have not submitted an application. You tried to avoid doing this. Now, I'm going to set this for the next hearing. You are to appear at the jail or at the sheriff's office. If you fail to do that, I'm going to issue a warrant for your arrest. I'm pretty close to doing that right now. Is that understood?
Yes, sir.
If you don't have an attorney, you need to apply for one. If you're
Okay.
wanting to have an attorney, otherwise you can represent yourself. I don't generally recommend that, but I'm not going to just keep continuing this thing so that you can just stretch it out forever. Do you understand?
I'm not trying to stretch it out, sir. I mean, everything was taken from me. I'm doing the best I can.
Mr. Schwartz, I've already gone over what I need to go over with you. And your next court date is going to be October the 17th. You are to appear at court security. And don't be calling around asking other people if that doesn't have to happen. You understand that?
I didn't do that, but yes, sir.
If you don't if you haven't hired an attorney, then you need to have applied for one, and you need to do that by Tuesday, October the 7th.
Yes, sir.
Mr. Regier, anything further?
Yeah, Your Honor.
This matter is adjourned and the parties are free to go. Thank you.
Okay.
All right. Mr. Patterson, are you ready on Mr. Whiteside?
Yes, Your Honor, all three of his cases.
All right. This is State of Kansas versus, is it Dayton?
It's
Whiteside. And there are three cases. 21 CR 493, 23 CR 129, and 24 CR 267. Counsel would state their appearances, please.
Jared Regier on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Denton Whiteside, who does appear from the Butler County Jail. Judge, I would tell the court that the 21 CR 493 and 23 CR 129 are warrant to show cause cases. That if we could take those up first, I would tell the court my client is going to waive hearing. He is going to stipulate to the violations contained within that, which failure to report and failure to pay. Judge, upon the court accepting his waiver, finding that there has been violations, there are agreed recommendations for the court. The agreed recommendation in this case would be to modify the sentence in 21 CR 493 to a 9-month controlling sentence that Mr. Whiteside serve that modified sentence with any credit for time. My review is that 23 CR 129 runs concurrent, so it would be knocked out at the same time. Thank you, Judge.
Okay, and that would be, if the court accepts that, the 9 months, approximately how much time does he have served already?
Judge, I have done a calculation with the help of the Butler County Jail. It appears that there are 172 days credit. So about 6 months credit.
All right. Mr. Regier, is that your understanding of the agreement?
It is, Your Honor. Upon successful entry of a stipulation in both these matters, the state's understanding of the agreement is that pursuant to negotiations, the state would recommend that the sentence in the 21 CR 493 be modified to a 9-month sentence. Reviewing the original misdemeanor journal entry in that case, it does appear that the court did order a 12-month underlying sentence back in August of 2022 when this matter was initially sentenced. It does appear that the court did order a 6-month underlying jail sentence as of January 2024 in the 23 CR 129 case. State does not oppose those running concurrent with each other, and there does appear to be indicated in the journal entry in the 23 CR case, quote, any jail time credit shall be awarded towards the underlying 6 months jail.
All right, so the journal entry is silent in regards to concurrent or consecutive?
One
Yes.
moment.
All right, and my understanding of the law is if it's silent as to concurrent or consecutive, it must be treated as concurrent.
And Your Honor, and that does appear to be an accurate reflection of the state's understanding of the law and the 2 journal entries in these matters.
All right. Mr. Whiteside, have you heard what the attorneys have told me?
Yes, Your Honor.
Okay, Mr. Whiteside, do you understand that you're entitled to a hearing on whether or not you violated the terms of your probation?
I understand, but
And you understand that the state would have the burden of proof by a preponderance of the evidence, or more likely than not?
Yeah, I understand.
Okay. And have you had sufficient time to discuss this with Mr. Patterson?
Yes, Your Honor.
All right. Are you, has anybody forced or coerced you in some fashion to enter this plea?
No, Your Honor, but if I may.
Well, you'll have an opportunity here in a moment. I've got some questions I need to cover first. Are you under the influence of any medications or intoxicants at this time?
No, Your Honor.
Okay. Anything that makes it difficult for you to think clearly?
No, Your Honor.
All right. Did you have a question in regards to entering the plea, or what was it you wanted to?
I just would like to say that I know that I've messed up in the past, and
Okay, I'll give you an opportunity to make those statements in a moment. Okay, I just wanted to be sure there wasn't a procedural thing that we needed to cover first. So have you had enough time to go over this with Mr. Patterson?
Yes, Your Honor.
Okay. And you understand that while there's a recommendation that your sentence be modified, the court is not bound to do that. You could be revoked in order to serve the sentence as originally ordered.
I understand.
Very well. And counsel, is there a stipulation in regards to the violations as listed in the affidavit in support of the motion?
That is so stipulated, Your Honor. Yes.
Very well. I find there's a factual basis that the plea is knowingly and voluntarily entered with the advice of good counsel. And I will find that Mr. Whiteside has violated the terms of his probation in 21 CR 493 and 23 CR 129. And as I understand it, the state is dismissing 24 CR 267. Is that correct?
The state is not aware of any disposition on the 2024 case being involved in this.
And that case will be set for trial, Judge. So
Okay, very well. So I'll hear counsel and also from the defendant, Mr. Whiteside, as to what should occur concerning his probation revocation. I'll start with the state, Mr. Regier.
Again, Your Honor, pursuant to plea negotiations, the state is prepared to recommend that in the 2021 case, the sentence be modified to a 9-month underlying sentence. The state does not make any recommendations pursuant to plea negotiations for modification in the 2023 case. The state is recommending that the defendant serve the sentences with credit for time served. The state is not opposed to these two cases running concurrent with each other pursuant to plea negotiations.
Well, that's been determined that they have to be concurrent. So, very well. Thank you. Mr. Patterson, anything additional?
Yes, Your Honor. Thank you. Judge, this is a case where Mr. Whiteside was an absconder. He was. Now, where he was absconding to was with his mother, who is ailing, is what I understand, has some medical issues that are pretty severe. So he did abscond and was taking care of her. But to his credit, Judge, and I'd ask the court to consider this, there was a warrant for his arrest. He was made aware of that warrant by the bondsman, Larry Kirkman. And he then, rather than have Mr. Kirkman face any consequences, he came back and turned himself in to Mr. Kirkman, who ended up, of course, taking him to jail. So he did come back voluntarily from taking care of his mother. So we would ask the court to consider the requested modification. Thank you.
All right. Thank you. Mr. Whiteside, is there anything you'd like to add?
Yeah, I don't know how much longer my mother has. She took on 3 foster kids that are under 4-year-old boys, and she can't hardly walk. So any leniency that you could show me would be heartfelt, because she needs me. But it's whatever the court decides.
Okay. Are you saying that this thing with your mother wasn't from when you initially started violating the terms of your probation more recently?
No, she's been sick for a while. That's why I went to Missouri. And she's had multiple surgeries. She had her stomach blow up and had to have her intestines removed. And it's been a long, slow healing process. But I've been there taking care of her.
And during that period of time, how did she come to be a foster parent with those medical issues?
Because my stepdad, it was his daughter that got in trouble and lost the kids, and they stepped up and took on the responsibility to help raise the kids so they wouldn't go to adoption, I guess. And they gave up their retirement to raise kids. And that was before my mother took ill.
Now, it looks like you weren't appearing and doing what you needed to do before what I'll refer to as the second case came along, the 23 case. Would that be a fair statement?
That would be a fair statement, because I still lived in Kansas at the time.
Counsel, was there restitution in 21 CR 493 or any other unpaid monies at this time?
Your Honor, the journal entry in the 21 CR 493 case does appear to refer to a restitution amount of $500. I would need the opportunity with the court's leave to review the public portal to make that, to advise the court further.
Your Honor.
Go ahead.
Your Honor, according to the notes I have, the 21 CR 493 case is paid in full, but he still owes $668 in the 23 CR 129.
Your Honor, if I may, I have a really good job over there where my mom lives. I help build churches and Walmarts and stuff, and I have a bank account that I have enough money I could pay that upon going to the bank and pulling it out.
All right. Well, you say upon going to the bank.
I have a bank card in my inventory here. I could just go to an ATM and pull it out.
All right.
I work 70 to 80 hours a week. So, and most of that is drive time, and I'm on call a lot too. So, but I'm able to sit at home and get paid while on the clock. I do a lot of the contracts, and I do the blueprints and stuff like that.
All right. As the restitution appears to have been paid in 21 CR 493, I am going to modify your sentence as requested to a controlling sentence of 9 months. I do revoke your probation. You'll serve out the remainder of that of that time, you'll get credit for time served. You've served on this case as well as 23 CR 129, as those were running concurrently. And so that should take care of those two cases. And so we'll take up 24 CR 267. Same appearances as before. Are there any announcements at this time?
Judge, we would ask that that be set for jury trial. I will file the appropriate document.
All right. I believe that trial date is, pre-trial is February 23rd at 9. Mr. Whiteside, if that matter is still going to be tried, you need to be appearing at the court security unless you're in custody, serving out your sentence here. I would think you'd be done with that by that date. Your trial date will be February 25th through 26th. But again, I want you to be sure that you stay in contact with Mr. Patterson. You need to make the arrangements to get that second case, that 23 case, paid off, and that'll be a condition of your probation. I want that paid within the next 2 weeks. So while you're there, if you fail to make that payment as you've indicated you could do, that's largely why I'm doing what the parties have requested.
Your Honor,
You said you're in a position to pay that.
I have my card in my inventory in the jail, I'd have to be able to get my card and
I'll let you make arrangements with the jail and or your bank. I would think there'd be a way of managing that so that can be paid.
okay.
So if they would work with you, I'd appreciate it in that regard. If for some, or, do you have somebody else on the account that can withdraw
don't.
money and
I'm the only person on the account.
okay, well, yeah, if you talk with your bank or something, I understand you may have limited contact information, but if there becomes a big issue, but I would like to see you get that taken care of as a condition of this probation. I don't want you to serve your sentence and then still be owing money on it. Okay?
Understood.
All right.
I have one more.
Hold on. So the other case is still for February 23rd. You're going to need to submit. I don't know if you have recently submitted an application for court-appointed attorney, what you described. I'm not. Of course, you're going to be sitting in jail for a while yet. Sounds like so. If you haven't submitted an application, you need to do that so the court can determine what's an appropriate attorney's fees, or if you qualify for court-appointed counsel. You're probably appointed because Mr. Patterson was already on the case on your first two cases.
Yeah.
Now, what else was there?
I have one last check that's coming. It should be here. I'd get it Friday, and it's going to my mother. I know my boss told me he was going to drop it off to her. I'm gonna try to contact him and see if he can write it out to her, and she can deposit it into her bank, and that way she can try to take care of it for me, and that way it would save a bit.
That'll be fine. Like I said, I'd like to see that taken care of in the next 2 weeks so that you've got that taken care of, and very well. So, counsel, anything further on Mr. Whiteside?
Your Honor, if the court wishes both the 2021 and the 2023 journal entries to reflect credit for time served under these circumstances, state has nothing further.
Yeah, I've ordered that he gets credit for time served, that can be calculated and included in the journal entry. Most jails are appreciative of having the paperwork that says when they're supposed to release somebody. So, very well.
Thank you, Your Honor.
Anything further?
Nothing further, Judge.
Very well. This matter is adjourned. Let's see.
Thank you, Judge Lee.
You're welcome. Let's see. Next matter.
Be safe, be well, sleep sweet, and much love.